Next, we move on to the next session of the day. Let me now cordially invite the following persons to chair this session, Dr. Satish Gunasinghe and Dr. Manjula Hera. This session is concerning the USI lecture, and the topic is medical records, ultimate defense. If we can please have Dr. Satish Gunasinghe and Dr. Manjula Hera onto the stage, please, to moderate this session. In the absence of them, let me cordially invite the President of the Sri Lanka Association of Urological Surgeons, Dr. Manjula Vijayawardena, and the Secretary, Dr. Karana Paranapalli Guruge.
So let me welcome Dr. Lalit Shah, President of the Urological Society of India, to deliver the USI lecture, Medical Records, the Ultimate Defense. Over to you, sir.
Good morning, everyone. So much thanks to Dr. Kalana and Dr. Manjula and SLAUS for inviting me to talk and providing me opportunity to share something which is different from urology. So I'll be taking you to an entirely different world altogether. Medical record keeping an ultimate defense, that is what has been asked. This basically relates more to the Indian scenario, but to more or less it will always be relating to other countries as well. Now the fact remains nowadays, can you trust your doctor? The doctor is God when the patient is ill, and doctor becomes devil when he sends the bill. Practicing in India is fast becoming an adventure sport. The things are very different from the day that we joined about 40, 50 years ago in the medical line and whatever is today. In any adventure sport, there are safety measures, but in medical professionals, practically there are no safety measures, and whatever cartoon that is seen may become a reality over a period of time. So why are we talking about it now? We never talked about it in earlier, maybe 20 years, 30 years ago, because the things were different. It is because of the medical negligence issues, Consumer Protection Act in India, and you would not believe, every year more than 5.2 million cases, that is 52 lakh cases of medical negligence are filed in the court of law. So whenever I say you, I mean we, and I'm very much included in that. In pre-CPA, that is the Consumer Protection Act, 1986 era, all the doctors in India were God, semi-God, next to God, super God, and whatnot. But post-CPA, they all, in cases where the things have not gone the way the patient and their attendants want, you are a villain. And we all need to understand very clearly that this is CPA, that is a Consumer Protection Act. It is not DPA, that is a Doctor Protection Act. In one of the surveys that we have taken, more than 40% of the doctors have received some or the other issues from the Consumer Protection Council complaint there, negligence issue. But fortunately, litigation needs perseverance, and over a period of time, people let go. Otherwise, probably it will be much more than whatever is happening. Then there is a myth that the government doctors are not under CPA net. It is a wrong thing. Government doctors are very much under CPA net. But fortunately, the patients and the lawyers also understand that the government doctors are not under CPA. That's why they get the benefit, and there are not too many cases against the government doctors. So there are compelling evidence that more malpractice is committed than can ever be recognized, litigated, or compensated. This was a statement way back in 1991. So whenever we are talking about that, we always think that it is not going to happen to me. It is probably whatever is talking, it's a good talk, nice talk, fantastic one, but it is probably for the neighbor, not for me. The basic tenet of the medicine is first do no harm. It is to err is human building a safer health system. This was in 2000, there was a study, Institute of Medicine report. It's a very, very large data, and it shows that the adverse event is close to 3%. An unfortunate thing is that more than 50% of it are preventable. So whenever the litigation is there, whether it was preventable or not preventable, the complainant would say that it was preventable and you would say it was not preventable. So the matter would be decided on whatever is the present in your records. In India, we say that there is no medical man in forum, so what he will understand. We took so many years to understand about the subject, and the layman who is not the medical man, how would they understand? But I believe that this is blessing in disguise, because it is much easier to convince a non-medical man about whatever you want to convince. Now, it is commonly said that the preoperative counseling would be the best thing, because if the counseling is good, your rapport with the patient and attendance is good, there would be no complaint. But when there is a litigation, the matter goes to the court, then your counseling goes down the drain, unless until there is a video recorded one. It goes down the drain. So it is only the medical records which is going to work. They say good record will be having good defense, poor record will have poor defense, and when there is no record, God only knows. In India, about 70 to 80% of Medicare is being provided by the small and the medium nursing homes, where the status of medical record keeping, pathetic is a respectable word. Probably there what happens is the only record or the only checklist that they have is whether the money has been deposited or not. And that is a very unfortunate situation. But what is the medical record? Whatever things connect with the patient, disease, medicine, investigation, nursing home or the hospital is a medical record. For all our practical purposes, OPD papers, indoor case record, informed consent, and discharge summary. These are the few things very important. And for urologists, most important thing is, a urologist or any variety of surgeon, the most important thing is the valid informed consent. Because most of the cases that I have been dealing with these cases, trying to defend my friends and colleagues since last 15 years in more than 500 cases, that I have been finding that the most of the cases which have gone against the doctor was because of the poor record of valid informed consent. So the consent has to be implied, valid, legal, adult, in condition to give consent, and most important is the patient himself or herself has to give the consent. This is talking about the non-emergency patient, non-emergency situation. This was the watershed decision in 2008. A 44-year female, she had menorrhagia. She gave consent for diagnostic and operative laparoscopy. Laparotomy may be needed. These were the exact words written. Patient underwent anesthesia. The surgeon did the laparoscopy and found that there is a widespread endometriosis and wanted to do hysterectomy with oophorectomy. So the attendant went out and took the consent from the mother. Later on, the patient and the fiancé created ruckus. They created a problem, went to the court, from one court to another one to another court, and ultimately it went to the Supreme Court of India. And the court felt, it was a watershed decision, that if laparotomy included hysterectomy with bilateral salpingo-oophorectomy, what was the need to have a separate consent from the mother? So what the doctor should have done? The Supreme Court says the doctor should have brought patient out of anesthesia, taken consent from the patient herself, and then should have performed the hysterectomy. But in addition, they have given a liberties. If it is an emergency or life-threatening situation, you don't need any separate consent. And if you anticipate something like this, then you should take a preoperative consent. Like say, for example, you are doing a stricture VIU, and you find a bladder neck there. So if you are anticipating, then you can take the consent that, okay, I'll do VIU, if required, plus minus, I will do bladder neck incision. But if you have not taken a consent and you go there, that means you are going beyond the consent and which is actionable. So what is the basic ingredient of consent? Nature of treatment, alternative. You have to explain risk and benefit of each and every procedure, and there should be opportunity for the question. And there should be sufficient time lag for the patient to swallow all those things, whatever you have told, and have a chance to retract the consent if they want. So the basic idea Supreme Court says is don't frighten into surgery and don't frighten out of surgery. When we talk about don't frighten into the surgery, say for example, there is a 3-4 mm ureteric stone, patient got a colic, GP has given injection, he became fine, he gets a sonography, naturally he will come to urologist. And then if you say that if you don't do ureteroscopy and I remove the stone, your kidney will fail and you may die, that means you are frightened into a surgery. And a villager who is an uneducated person, and you are talking about pulmonary embolism and all other things like this, when he has come for a simple hydrocele surgery, that's not fair. That is what Supreme Court wants, seeing the socio-economical and the educational standard of cross-sections of patients in India. So, but for a direct question, you should give a direct answer. The direct question, after whatever amount of counseling you do, is very simple. Is there any risk? Can I die? Then you have to talk about. If you ask yes and no, it is yes. But then you can put the rider. Then 40 years of my experience, nobody had died. We have done the preoperative workup, etc., that you can tell them. Then it has to be in the patient's own language. Maybe over a period of time in India, we will see the outpatient will be like this, that the patient understands all those. The consent has to be in the patient's language. Another thing which I require, when any consent is basically an agreement between the two parties, and doctor is the one party. So if the doctor's signature is not there in the consent form, it is an invalid consent. This is at my place, that what I recommend. In patient's handwriting, I like to ask the patient to write in one sentence that I have been told about the disease, surgery, and anesthesia in details in my own language. If the patient signs that, you are safe. And this particular thing has saved me, myself only, in one of the cases which was put against me about 4 years ago. Then why should we keep the record? Because this is the legal requirement, and that is the best defense in the court of law. In this particular case, it was rupture of appendix occurred due to delay in surgery because the consent was not given. My uncle is coming, my father is coming, my brother is coming, please wait, so on and so forth. So the doctor was held negligent because they have not taken the informed refusal. So if they have not taken informed refusal, it is your fault. It is said in Consumer Protection Act that the burden of proof is on complainant. But in general, unless until you are, they play just like a third empire. So unless and until your defense is watertight, you are going to have trouble. Another thing is court does not take a good view where it appears that someone is hiding possible piece of evidence. Many people say, okay, I will not write anything. I will not give any discharge paper and all that. So the court does not like that. And now your records are like scar. If your scar is good, probably the quality of care that you have provided is good. Another thing, like I said, about the informed refusal. Then another thing is what happens is when the case papers are not, like I said, completed in a regular basis in a prospective manner. When the notice comes, you pick up the file and then you try to complete the records. So what happens is that in one flow with one pen, one ink, you write for 3 days notes. So that's why the record should not look too perfect because there had been court decisions which say that the doctors are known for non-perfect record. So if it is too perfect, they assume that this is an afterthought and prepared later on. It should not look like cooked and manipulated. Fortunately, in India, so far, for the age of the record, ink imaging, handwriting expert opinion, and DNA fingerprinting is not utilized so far. Another thing that I suggest is a discharge summary. Your discharge summary should be very elaborate and clear because whatever you are writing in discharge summary goes with the patient, which you cannot go to his house and change later on. So whatever you have written, whatsoever you have written, becomes a gospel truth. That cannot be challenged, that cannot be questioned. Because everybody understands, the complainant, their lawyer, and the judges, people sitting on the judgment chair, that the indoor case file is with you. So at any time, you can always add something, manipulate something, alter something. But discharge summary is with the patient and gone, so that cannot be changed. Another thing I say is whenever, in addition to being a good clinical diagnostician, you should become a good social diagnostician as well. You should be able to smell that this patient is going to create problem. So there may be after 100 patients, there is 1 or 2 patients. It is much better that you say that I am a small man, I have a small hospital, please go to some higher center and a bigger doctor. Please go to him, though 98 people will be running your kitchen fire burning, no problem at all. Like another thing that I recommend is a discharge consent. It is not a proper word, but I could not get any better terminology. And this is where we say that that we certify discharge summary, investigation have been given to us, nature of problem, prognosis, plan of management, treatment given in the hospital, possible complications, failure, need for regular follow-up and precautions, and follow-up procedures, etc. have been explained to us in our submission. So this helps because commonly it happens, say for example, you have done a VIU, patient goes and comes back after 3 years. Oh doctor, I am getting the same thing again, while you have returned to come back for 1 year after 1 month. But he has lost to follow-up. And the periodic counseling record, if required. And another thing is all prescriptions should end OPD, discharge or follow-up with a review after, call for review. There has been one case where a senior urologist had been punished because he did not call for review, and the court wrote on the judgment that the doctor and the hospital abandoned the treatment, patient did not abandon the treatment. So ask him to come after review, maybe after 1 week or 1 month and all that. Moreover, it is financially good also. He will come, he is going to pay you fee. What is the problem in that? Another question is how to correct your record. The white inking or painting it just like that so that it cannot be read is not correct and is not taken properly. So how to correct the record is very simple, because commonly we write and then suddenly we realize that no, we want to change this particular sentence. So you have to cut in one single straight line in such a manner that you are able to still read what was written. And then you can write whatever you want to write, put your signature, date and time. That is the correct legal way of correcting a record. How long to keep the record? In Indian scenario, keeping it about 5 years is good enough, unless until the case is running or various other acts. So time to change Hippocratic oath. In our Hippocratic oath, there is one thing very clear. They say for the benefit of patient, for the patient, it was there, it is there, it will always remember there, but I would like to add, not at the cost of my skin. I love my skin and I'm sure everybody else's skin is also good. So it is our responsibility to take care of our skin. So the take-home message will be honest to yourself and your patient, keep good medical record, always take a very good informed consent, don't be a very good salesman, have requisite qualification, don't take case beyond your capability, moreover, don't take case beyond the capability of your setup. Like say for example, I may be doing a good TURP, but I have a small nursing home of 10 bed. I don't have a cardiac ICU, I don't have a cardiologist attached with me in my hospital. So if I want to do a TURP on a patient who has ejection fraction of 15 or 20%, and if I am doing at my nursing home, it is per se negligence. I have to take a patient to a multi-specialty hospital where all these facilities are available, fair enough. Don't take case any without workup. Don't take case on the basis of only USG report by somebody else. Don't hesitate to take second opinion, need to convert, need to open, need to refer it to somebody else. Cover yourself with the hospital with professional risk management, indemnity insurance, and last, most important, please prevent preventable medical errors. Thank you. Thank you very much for the patient listening. God is great. God has been kind to all of us. Let us hope you are glad. Thank you.
Thank you very much, sir. Let me now invite one of the moderators to hand over the gift of appreciation and the certificate to the speaker.